One of the things that really confuses people when it comes to Oregon state law is that Oregon gets to make laws regarding firearms for their entire state, just as any other state does. But what feels a little backwards to a lot of people is that while Oregon makes state laws and training standards, the counties and municipalities all get to make their own training standards that can be tighter and tougher to accomplish than the Oregon state ones. So what will happen a lot of times is people will go to a class and they're promised that they're going to get this certificate for their Oregon Concealed Handgun License, or CHL, and they leave the class and they go down to the county sheriff that's nearest to them in Oregon and they hand over their certificate and they say, yeah, I'm here to get my CHL. And they go, no, we're not going to give it to you. This document's not good enough. And the person goes, but why? It fulfills the Oregon state laws training standards. And they'll say, yeah, it sure does. It doesn't fulfill our training standards. So very important to note that, again, each county and municipality gets to make its own set of laws regarding training standards. That's why it's good that you're taking this course today, because one thing that is important is that Columbia County, which happens to be just on the other side of the Washington border, actually recognizes the Safe Insight Multi-State Certificate, or the Oregon CHL certificate that you're going to get for that particular one. They will recognize that they will issue to our students that have successfully completed our course. And it's important to note too that Safe Insight is one of only 2 firearms instruction companies in Washington State that's recognized by the Oregon Firearms Federation as being certified CHL instructors. We're the only one in the greater Seattle area. So again, this is good that you're taking this training today and getting a chance to learn a little bit more about Oregon laws, how they work, how they apply. Now, another thing that we need to talk about when it comes to Oregon laws is concealed carry versus open carry. So we're going to take a minute, we're going to compare Washington laws with Oregon laws. So the first thing we want to talk about is, what is concealed carry? Well, take a minute, answer it. Try to define it. Put it in your own words. What is concealed carry? Well, concealed carry quite simply means I'm carrying a firearm, and I'm carrying it in a concealed manner. I'm not showing it off blatantly. I'm not walking around with it exposed. I'm keeping it concealed. Much as I'm doing right here. I have a concealed firearm on me, but as you can see, I'm not exposing my firearm. You might have picked up on where it is because I now told you that I have one, but just looking at me prior to this, I'll bet you didn't realize I was carrying one. And that's because I'm concealing it on my hip. So my firearm is concealed. So it's very important that when you're carrying a concealed firearm, you actually conceal it. So what does open carry mean? Well, open carry would mean I've taken my firearm and I've now put it right outside of my shirt and I'm showing it off and I'm walking around town with my open carry firearm. So very important to understand, is open carry legal? So let's start with Washington State. Is open carry legal? Well, in Washington State, open carry is legal by RCW, or Revised Code of Washington, aka the law. Open carry is legal in Washington State. Now, is open carry a good idea? Now we're into a different territory. The reason why we say this is because while open carry is legal per Washington State law, it becomes blurred and it can become a little bit complicated, creating problems for yourself if you don't understand how the law works. So what I can tell you is that from my experience in law enforcement, there's a lot of police officers that don't understand how the law works when it comes to open carry versus concealed carry. I don't say that they don't know the law because they don't take the time to try to learn things. I say it because they're bombarded and flooded with laws that they have to remember in all sorts of aspects. And when it comes to firearms, laws are constantly changing, so it can become tiresome and tough to keep up on the laws that need to be enforced. So with that being said, while open carry is legal, one of the problems that it causes is when you bring the assault statute into play. Because a lot of people don't realize in Washington State what assault truly is. So by definition, by RCW, Revised Code of Washington definition, Do I have to touch you in order to assault you? This is probably a question you should know the answer to. It's not one that everybody does. And here in Washington State, the answer is no. I don't have to touch you to assault you. What I have to do is make you feel like you were in imminent threat of being touched in an unwanted manner. I can do that with my look, with my behavior, with my words, with exposing my firearm to you. Do you see how this can become a little bit complicated? So while I might not have intended anything when I walked around the grocery store with my firearm, open carried on my hip, I'm just exercising my Second Amendment rights and my Washington State law rights. While I might not have intended anything, the first person that looks at it and feels in fear and says, I feel like he was threatening me, they are claiming that you committed assault. Now here's where the tangled web begins, because now whichever police officer shows up on the scene has to sort that out with their best understanding of the law. So as you can see, this can get a little bit complicated. I've watched it happen. I've watched people get arrested for open carry, and later on after processing and whatnot, it was realized that no, this really isn't actually a crime. So they were let go, and you could say, well, that's what the courts are for, and I'll sue them. And okay, if that's the route you want to go. All we're trying to explain to you is that open carry can create some unwanted complications for you by bringing it around. The second thing that goes with open carry, and that we try to really enforce to our students, is that when you open carry, what is the purpose of open carry? Well, a lot of times people say, well, I'm trying to deter a crime. I don't want somebody to think I'm an easy victim. I'm going to show them that I'm not the one they want to mess with that day. Okay, we can understand that, but at the same time, think about what you're really saying when you carry that firearm in an exposed manner. You're saying, I've got a gun, don't mess with me, I'll hurt you, right? So while it's probably true, you probably have deterred the pickpocket that was going to come up and stop you and try to take your wallet. He's probably going to go to the next target. Okay, fair enough. But what about somebody that was intent on doing a crime that day? Let's say you walk in the bank and you've got your firearm open carried because you're not going to be a victim today and you're letting them know that. What happens to the person that has planned out their bank robbery, and they've planned it out to be a takeover type robbery? They're going to come in with guns and they're going to take over the bank. What do they scan for when they walk in? Who's my threats? Security guard, if there is one, because he's probably got a weapon of some sorts on him, firearm or other. And who's got a firearm on him in this bank? Ah, Joe Schmo over there has a firearm. He's probably going to be a threat to my plans today. Take him out first, and then I'll get on with my business. So what you've probably done is put a target on you. You understand? You might not be the victim of an everyday crime, a personal crime, but you've probably put a target on you if it comes down to a bigger crime that's about to go down. And realistically, what are we carrying a firearm around for? Are we there to defend ourselves against a pickpocket? Absolutely not. If you use your firearm to defend against a pickpocket, you've just broken the law. Because in order to use deadly force, you have to be in imminent fear of either death or serious bodily harm. And if you can't justify that to 12 members of a jury that you felt imminent fear of one of those two things, then you just violated the law if you use your firearm in self-defense, even if it's just pulling it out and pointing it at somebody, because that is constituted as deadly force under Washington State law. So important to know what you're probably carrying the firearm around for is to deter the bigger crimes that you see. Somebody that comes up and attacks you or your family. Somebody that you see trying to do a takeover robbery in a bank while you happen to be there. That's probably what you're carrying your firearm for, if you're carrying it in a legal manner. So if you're carrying it openly exposed, what's happened is you are now creating a target for yourself and you're getting rid of your ace in the hole. By keeping it concealed, you've got an ace in the hole because somebody scans around, they don't see you got a firearm, they go on to do their business, and now you have an ace in the hole that you can pull out and use as a tool to stop that crime and prevent it from happening. So it's just, it's an opinion thing, but we like to put out some things to think about if you're going to open carry. The other thing is, bear in mind where you're open carrying at. Over in Western Washington, it's a lot more complicated to open carry than it is in, say, Eastern Washington over in the mountains. Because it's just the culture. When you go to Eastern Washington, if you've ever been over there, there's a lot more hunters and that type of thing that takes place. People don't bat an eye typically over somebody open carrying. In heavy areas like the Seattle metropolitan area, you're going to get frowned at and you're going to bring some unwanted attention on yourself. So bear that in mind when you debate open carry versus concealed carry. Now, let's talk about Oregon state law when it comes to open carry versus concealed carry. So we talked about Washington law. Is open carry legal? Yes, it is. Is open carry legal in Oregon? Oh, by state law? Yes, it is. It sure is legal in Oregon. But what did we discuss about Oregon state law when it comes to firearms? That's right. The counties and municipalities all get to make their own tighter laws if they so choose. So guess how many counties and municipalities you can open carry in Oregon legally? Very few. None of the major ones that you're thinking about. Portland, Beaverton, Tigard, Medford. None of those areas can you open carry in legally. In fact, it's an arrestable crime to open carry in those areas of Oregon. So, when it comes to open carry in Oregon, even though state law says it's legal, for all intents and purposes, it is illegal to open carry in Oregon. Let's talk about where we might want to carry our firearm. In Washington State, if we want to carry our firearm around in our house, is it legal to do that? Absolutely. You don't even have to have a permit to carry in your own home in Washington State. So if you wanted to have your morning cup of coffee, step out on your porch, have a sip, have your firearm concealed, open carry, whatever you choose, you're on your porch, right? How about in Oregon? Well, in Oregon, the front porch of your house is considered public property by firearm statute definitions. Meaning, if you step out open carrying onto your front porch, guess what you just did? Violated the law. You put yourself in an arrestable offense if somebody was so inclined to arrest you for that. So very important to know that those firearms laws are drastically different when it comes to where you can and cannot legally carry a firearm in Oregon. Now, one good thing to know about Oregon State is all these things we talked about with concealed carry and where you can and can't carry and all that. It's important to know that if you get your CHL, your concealed handgun license in Oregon, guess what? State law now says that the CHL overrides the county and municipality laws regarding firearms carry. What? Once you get your concealed handgun license in Oregon, you can now carry open or concealed anywhere you want other than the legally prohibited places, which we'll talk about briefly. So Oregon state law says that once you get a concealed handgun license there, it overrides all county and municipality decisions on firearms. You are now covered in a blanket to carry in any locations that are okay per state law. So where can you not carry in Oregon? Well, Oregon, much like many other states, has a few prohibited places. You generally can't carry onto public transportation modes such as airplanes, trains, whatnot. You can't carry into the courthouses. You cannot carry into federal buildings or legislative buildings. Now, one thing that is very unique about Oregon, in fact, they are they are the only one of the 50 states that this is legal in. There is one place you can carry that 49 other states say you cannot carry a firearm. You want to guess where that is? Schools. In Oregon, you can carry onto school property. In 49 other states, including Washington, You cannot carry onto school property. What about businesses that have signs up that say, firearms prohibited? Can you legally carry a firearm into a place that says, firearms prohibited? Well, let's start by talking about the Washington state law and how that works. So one of the ones we like to talk about because it's one of our local favorites, and plus it has a really unique situation going on behind it, is Starbucks. So Starbucks, for the longest time, for those of you that weren't aware, used to be a gun-friendly place. They encouraged people to bring guns in. They were fine with it until some groups got together and kind of pushed the envelope, went a little too far with it, and made kind of a showing out of it and made other customers uncomfortable. Now Starbucks says, no firearms allowed on our premises. So what happens if you have a firearm? Let's say you decide to walk into the Starbucks, and let's just say you decided to open carry it, because that's your Second Amendment right, and it's supported by Washington state law, and you wanted to open carry into Starbucks, and you're carrying your gun on your hip, and you come walking in, you said, I'd like to order a coffee, please. Triple grande latte, hold the cream with a splash of, you get the point. So you order a coffee. They look at the gun on your hip, and they say, sorry, sir, you're going to have to leave. We don't allow firearms here. What happens? Well, you get to play the pick your own destiny, right? Because you've got two choices to make now. Either you can go, oh, understood, and you can leave. Or you can say, this is my Second Amendment right, and I will carry in here if I want to because state law says that it's legal. What's going to happen? Well, if you turn around, walk out the door, no harm, no foul, right? They simply refused you service. But if you stand there and say, I have the right to carry and I'm going to carry and you can't make me, now they get to say, sir, we're letting you know that we don't want you here with your firearm, so you're going to have to leave. You say, it's my Second Amendment right, and I'm going to stand here and I'm going to do this. Okay, well, now one of the employees is going to be tasked with calling 911. Yes, we have a customer here that we need removed, and you will get to exit the building, only you'll get to do it escorted by one, maybe two police officers, and you'll get to wear pretty silver bracelets on your way out. And you get to take a free ride in the squad car, and you may get a free hot meal that afternoon in the city jail. But what happened? What did you get arrested for? If you take that route, you got arrested for trespassing. You got arrested because you refused to leave when a private business asked you to leave and chose to refuse service to you. Do private businesses have the right to refuse service to you? Absolutely. And if they deem that they don't want the firearms there and they would like you to leave, then they can certainly refuse service to you and ask you to leave with your firearm. That's their prerogative. So, when you got arrested for trespassing, did you get arrested because you were carrying a firearm? No. Your firearm never came into play here. You walked into a business that said no firearms allowed. You carried a firearm in there anyways. You chose to stay when they asked you to leave. You got arrested for trespassing. The firearm was not the reason you got arrested. You got arrested for poor decision making after you were asked to leave. It's important to make this distinction because what we're getting at is that when you're in the store and they refuse service to you, nothing happens with you carrying the firearm. It is not illegal to carry a firearm into a business that has a sign that says no firearms permitted on this property or whatever the case may be. They can make whatever signs they want. They can make whatever requests they want. They cannot legally prohibit you from bringing the firearm into their business. What's the distinction? The distinction is if you walk into a place that has a sign that says no firearms permitted per RCW ... that specifically cites a law where it's prohibited. You might see this in a courthouse or other locations. If you bring a firearm in there, you can be arrested for bringing the firearm into the building. Even if you choose to turn around and leave, you can still get arrested for bringing the firearm into the building. In a private business, you cannot be arrested for bringing the firearm in. You can only be asked to leave and refuse service to. So what about in Oregon? In Oregon, There's a little bit different thing to note, and this is true in multiple other states as well. In some states, including Oregon, signs have the force of law. So, if they say, no firearms permitted, and you walk into the Starbucks in Oregon with that sign up there, you can be arrested for carrying the firearm into the Starbucks that says, no firearms permitted. So that's a big difference to note, is whether a sign has the weight of law or not. So again, if you walk into a business that says no firearms permitted in Oregon, you have now violated the law, and you can be arrested for carrying the firearm in there, as opposed to in Washington State, where you would only be arrested if you chose to stay and trespassed. So very important to note that signs have the weight of law for private businesses in Oregon. What is deadly force? Deadly force means the application of any tool or use of force that is reasonably likely to cause death or serious bodily harm. So it's important to know, if you choose to use a firearm, what level of force are you using? Deadly force. We talk about this because a lot of times people say, well, if I had to use my gun and somebody was trying to do something to me, I'd just shoot him in the leg, I'd shoot him in the arm. I'm not going to shoot to kill. I'm going to shoot him in an area not to kill him. Well, why is it important to know what deadly force laws are? It's important to know that when you're using deadly force, you can only use deadly force to prevent imminent death or serious bodily harm to yourself or another. You don't get to use deadly force to protect property. You don't get to use deadly force to protect yourself from some sort of a minor assault. You get to use deadly force to prevent imminent death or serious bodily harm. And just so you know, the courts have kind of defined through rulings serious bodily harm to mean that's something that's going to require more than an in and out trip to the hospital. Something that's going to basically require you to stay at least overnight. In general, that's how they define serious bodily harm. So, if you walk up to me and say, hey, I'm going to punch you in the nose, and you punch me in the nose, did you just cause serious bodily harm to me? Well, it might hurt really bad to me, but it doesn't meet the standards of serious bodily harm. So would I have been justified in pulling out my firearm and saying, oh no, you're not going to punch me in the nose? Absolutely not. I do not get to use a firearm for that type of a situation. I only get to use a firearm when I am protecting myself from imminent death or serious bodily harm, or one of those two things to somebody that is around me. That's the only time I get to use it. So, what happens if I pull my firearm out of my holster and point it at you? I'm using deadly force whether I press the trigger or not. Doesn't matter. I'm using deadly force because I've pulled my firearm out and presented it as a use of force. This is important to note because if you do press the trigger and fire a bullet and strike somebody with it, it doesn't matter if you strike them in the leg. It doesn't matter if you strike them in the tip of their finger. Guess what you used against them? Deadly force. Now, what happens whenever you use deadly force? You're going to court. I promise you, you're going to court. You're going to have to defend your use of deadly force, no matter how justified it was. And you better hope it was justified, because you're going to be put through the ringer in court to make sure that what you did was justified. And what's going to happen? The defense attorney is going to get a hold of you. They're going to say, oh, well, sir, I see here that you fired at my client and you shot my client in the leg. And you say, well, yeah, because I didn't want to kill him. I didn't want to hurt him too bad. Oh, I see. So you used deadly force on my client, but you didn't feel threatened enough to really stop his attack. You just wanted to teach him a lesson? And you're going to say, well, no, that's not what I was saying. Oh, well, what were you saying, sir? Well, what I'm saying is that I just wanted to shoot him to deter him from a further attack. Oh, so you just wanted to deter his attack. you weren't really threatened. You didn't really feel imminent threat of death or serious bodily harm. Oh, well, yes, I did. Oh, you did. But you didn't want to stop the attack. You just thought, do you see where we're going with this? You're going to go in a big circle and you're going to get yourself caught up. And the ultimate thing is, you're going to, when you go to court, get charged with either, if the person did end up dying, say you shot them in the leg and they bled out, you're going to get charged with murder. Or if you shot them in the leg and they just bled and got an injury and then were there in the court to testify against you, you're going to get charged with attempted murder. Or at the very least, use of deadly force. So the point is, you're going to have to defend these charges. Now, that might be shocking to hear that if somebody died, that you'd be charged with murder. That is a charge that's going to come up. You're going to have to defend that charge is the point. You're going to have to explain that what you did was called justifiable homicide. It's still a homicide. It's just that there are circumstances that justify homicide. So again, if you're going to pull your firearm out and use it as deadly force, remember that's what you're using is deadly force just by pulling it out. Make sure that you're justified to use it. Make sure that you or someone near you has an imminent threat of death or serious bodily harm.